Thanks, Paul, and thanks to the rest of CSI for letting me do this again. It's an honor and pleasure to be here. For those of you taking the class, you could be forgiven for thinking that the A201 is this giant, annoying, boring piece of paper, but we're going to do our best to try to make it interesting and use a lot of charts and graphs to illustrate some things which probably wouldn't be apparent just by looking at the document. But hopefully by the end of this presentation, you're going to say that you can see where it fits into the larger puzzle, and hopefully it makes a lot of sense. The presentation usually runs about 90 minutes. I've been giving this talk for about 20 years. And what I've done is I've set out a fairly ambitious slide deck. It has over 50 slides, but I intended it kind of as notes because I wouldn't imagine that you guys are going to be able to keep up with note taking. So if Paul could circulate the slide deck to everybody when this is done, or if he wants to do it sooner, that would be great, because a lot of the things that are important for you to take away from this presentation, you probably can come back and look at the slide deck and cross-reference the A201, and it's my hope that that presentation will be of use to you. Also, as I said, I've been giving this talk for many years, and I've come to know many of the people who have heard it very well, and I would be delighted to get to know all of you. And so whether it's LinkedIn or an email to me or whatever, please reach out with any questions about this or anything else about design and construction law. And so without further ado, I think I owe you an explanation first about why you should care about any of this, because who really cares about reading construction contracts other than people like me? And I'd say that I believe that the A201 is the AIA's most important contract document. It was first produced in 1911. It was amended 15 times through 2017. This is the version that we're going to be looking at now. And I have in the past taught a course at John Marshall Law School here in Chicago, where we centered much of the curriculum around the A201 general conditions. So this is really, if you're only going to know about one contract, this is a good one to know about. I don't have any empirical data on this, but it's my observation for having been a lawyer in the space for more than 20 years that I believe the A201 is used on more projects in the United States than any other contract form, certainly private projects. And it's very important for the construction phase. It's very important for construction administration. As a matter of fact, most of what you anecdotally know about what an architect does during CA, it comes from this document, right? So who's responsible for site safety? Who's responsible for means and methods? You probably all got some knee-jerk thoughts about that. Those concepts are expressed in the A201. And it's not a bunch of legalese, even though it's a long, boring document, and even I don't like to sit down and read the thing, it's a practical tool for project managers. It's a desk reference for the CA phase. You get in an RFI or a submittal or something, you've got a question, you don't know what to do. The answer is probably in the A201 if it applies on your project. And so I like to, facetiously suggest that, project managers should have a laminated copy of the A201 chained to their desk, because it's not just a bunch of legalese. It's a real practical document. If you were to do a word search, you would see that in the A201, the word architect appears more than 300 times. The word owner appears more than 400 times, and the word contractor appears more than 500 times. And the reason for that is that this is the document, the A201, that is kind of the compromise between how the owner, the architect, and the contractor are going to play nicely in the sandbox together, right? If you put yourself in the shoes of a general contractor, do they want an architect reviewing and thumbs up or thumbs down on their pay applications? No, the GCs don't want the architect to do that. They just want to submit it to the owner. Does the GC necessarily want the architect walking the site, making site observations, and reporting back to the owner on what's good and what's not? Probably not. General contractors would prefer not to have that. But because of the A201, which is this sort of compromise document, this document that sits between the owner and the architect and the owner and the contractor contractually, and spells out like, what is the architect going to do during CA in terms of deciding when substantial completion is achieved, and passing on pay-apps. Like, this is the document that expresses the role that the architect is going to play, kind of getting between the owner and the contractor. And this is the reason why, GCs get their pay-apps certified by architects, and the architects get to, report back to the owner. Technically, it's part of the owner-contractor agreement, and I'm going to explain why that is with some diagrams that will make it very clear. But as you can see, it says architect in here more than 300 times. So there's a lot of requirements in here for architects, and it puts the A201 in that familiar role of the owner's protector, right? It's, as I suggested, it's the owner says, hey, contractor, I'm going to empower the architect to get between us. And, the contractor says, okay, subject to certain conditions. For example, the architect should act on pay-apps within a week. That is kind of the give and take here. It's what I've found is that CA work, construction administration work, it makes up a large part of an architect's compensation on a lot of projects, at least here in the United States. And I think that one thing that might surprise people who don't think about construction contracts that much is that role for the architect and the fees that it is entitled to in CA to do this sort of role between the owner and the contractor. I don't think that we can take for granted that just because that's how it's been historically, that role is going to necessarily continue on into the future. Over the last 2 decades, there have been other industry groups besides the AIA, industry groups that are formed largely by contractors that have their own standard form agreements. And if you were to look, for example, at some of those other contract forms, which is essentially the equivalent of this A201 general conditions, those contracts barely mention the word architect at all. The only time that the architect is going to be involved during construction is when the GC really needs something, like, there's absolutely a shop drawing that they need the architect to weigh in on, or if there's a stamp, that's required, or certainly not going to put the architect front and center, in the role between the architect and the contractor. And so, I know that not everybody that's watching this presentation is an architect, but I do like to say to architects when I give this presentation that, if you are working for a firm that does CA and you get substantial fees from it, I think that as someone in your industry, you should be really interested to understand this document, because if the trend in the industry was to get away from using the A201 and to minimize the role of the architect in CA, it's a lot less fees for design firms, and maybe a lot less jobs available. I'm not here to make an endorsement of one form or another. I'm only wanting to point out what the significance of this form is, for owners, architects, and owners, architects, and contractors. And so, with that said, who am I? I'm not a real estate lawyer. I'm a design and construction lawyer, which is a way of saying that I help people create buildings. My clients are property owners and real estate developers and architects and engineers and contractors. One of the greatest honors of my career is that I can say I'm a liaison to the AIA Contract Documents Committee, which is a fancy way of saying that when the AIA writes its standard forms, they take input from a lot of different people, and occasionally they will ask me for my 2 cents on how their standard form should read in the future. I taught construction law at John Marshall Law School here in Chicago for a number of years, and I was a lawyer at a big firm for most of my career until I started Baker Law Group LLC. There's a little typo on the page I'm seeing now, in October 2019. And who would have thought that right before the pandemic was a bad time to leave your cushy big law firm job and start your own firm. But enough about me. Let's talk about the agenda today. So before we're going to get into any kind of nitty gritty, I want you to understand what are the projects where you need to care about the A201 general conditions, because there's a lot where it just doesn't apply and you could throw all this out the window. So that's kind of the first agenda item. The second thing we're going to discuss is how this A201 general conditions document works with other AIA contract documents. Then at the end, we're going to review what I believe are the most important specific provisions. When, for example, does an architect need to produce a writing, as opposed to just let people know things verbally would be one example. So we'll lightly at the end review some specific provisions, and that part of the slide deck is going to be like the notes for you, where I would hope that you would be able to look at the slide deck and cross-reference the A201 itself to prepare for the exam. And then at the end, we'll do a question and answer session. I don't know how many times I've given this talk, 20, 30, or more, but most of the questions that come up do get answered in due time, but I will hang out afterwards and answer questions. And as I mentioned, any of you can email me, or ping me on LinkedIn. I'd be happy to chat with you offline as well. So, what a lot of you probably know is that the AIA has been producing standard contract forms for more than a century. Most of the major agreements like this one, the A201, are revised on a 10-year cycle. So the A201 2017, which is what we're going to talk about today, is going to be good until 2027. So if you invest a little bit of time learning about this, it won't be a wasted time, because this is likely to be relevant for a while. But as I mentioned, we're on like the 15th revision of the general conditions. And while I'm sure it'll change in 2027, it's not going to change, that much. So, that's a little bit about AIA contract documents. And this slide deck might look confusing, but it's not. Lawyers love charts. And what you see here is a project delivery method. This is the traditional structure. So lines represent contracts. And you could see that the owner of the project has separately hired separate contracts, the architect and the design team on the left side of the slide, which is represented by the gray boxes. I'm sure all of you are not confused by that. And if you look to the right-hand side, you can see that the owners hired a GC to do the construction work, okay? And that A201 general conditions is what sits in the middle of the contractual relationship between the owner and the architect and the owner and the contractor. I mean, if you think about it for a second, if the GC doesn't have a contract with the architect, why should the GC care at all what the architect has to say? Well, the answer is this A201 general conditions document. I'm going to show you a few more diagrams that are very similar to this one. What you see here is almost exactly the same diagram that we looked at a minute ago. It's just expressed a little bit differently. So as you can see, the owner at the top has separately contracted with the architect to the left, and the architect hires its subconsultants. And on the right, you can see the owners hired the contractor, and the contractor has bought out the trade work on the right. And you can see that triangle that represents the relationship between the owner and the architect and the owner and the contractor. And because the architect and contractor don't have an agreement with each other, there's a dotted line that attaches the owner and the architect. And what holds them all together is the A201 general conditions document, which works with a number of different AIA contracts. I've set out some of the A series agreements. The A101, for example, is kind of the flagship owner contractor agreement. If it's an AIA document, it starts with the letter A. That means it's an owner contractor agreement. If you look to the left, the B101 is kind of the flagship owner architect agreement. If an AIA contract document starts with a B, chances are it's an agreement between an architect and an owner. And so one of the things I really want you all to understand is you only need to care about the A201 general conditions if it is a project where the owner has separately hired the architect in one contract and separately hired the GC in another contract. And there are some other similar arrangements to that we'll look at, but that's the hallmark of when you care about the A201 general conditions. If you have AIA contracts that point to it, and if the delivery method of the project has the owner separately hiring the architect and the contractor. Now, I'm pretty sure the next slide is complicated if I'm thinking of the right one, but this is actually not that complicated because it's just exactly what we were looking at a second ago. It just goes to show some of the different contract forms. So, right, everybody can see the owners reflected by the black box in the middle. Again, lines represent contracts. To the left of the owner, a solid line over to the architect, listing of the B series contracts that might be used for the owner to hire the architect, right? And underneath the architect, you can see a solid line connecting it to its subconsultants, and perhaps they're using the C401 architect subconsultant agreement. To the right-hand side of this slide, it's not complicated either. The owner has a solid line connecting it to the contractor. That means that the owner's got a contract with the GC, and you could see some of the A series AIA documents that might be used in this arrangement. And the key thing I want you to notice is the orange box that sits in the back. At the risk of beating this horse to death, I want you all to understand that when the owner has separately contracted with the architect and separately contracted with the contractor, that's when the orange box is going to sit in the background and be relevant. All right. Now, you may notice that there's no orange box here for the design build project delivery method, right? You can see in this case, there is no line connecting the architect and the owner. It's because the architect and the owner don't have a contract with each other. There is no solid line connecting the owner and the contractor. It's because the owner and the contractor in this project delivery method don't have a contract, right? The design build method of project delivery, as most of you know, is what some people refer to as the one throat to choke method of project delivery, because the owner goes to one party, the design builder, for both design and construction. And if there's a construction problem or a design problem, the owner's only got one throat to choke. It's the throat of the design builder, right? And there are trade-offs associated with this. The owner is not, in a project delivery method like this, going to get the benefit of the architect making site observations and making, reporting back to the owner on the quality of construction. And it's not going to be certifying pay applications and doing the other things that are discussed in the A201, because that's the fundamental trade-off. The owner in this project delivery method has decided that it's going to have one party, so you don't have the architect pointing at the contractor for a problem and the contractor pointing at the architect. The owner's got that single point responsibility that's so useful. Part of the trade-off, though, is that they don't get those sweet nothings whispered into their ear by the architect, because the architect isn't working for the owner, it's working for the design builder. So on a design build project, the A201 general conditions does not apply. If we stop the presentation right now and you learn nothing else, that is the most important thing you have to understand, is when can you ignore the general conditions and when does it apply? Now, there are a number of other project delivery methods where the owner separately hires the architect and the owner separately hires the contractor. Some of you may be familiar with the construction manager as constructor method of project delivery, which is also known as construction manager at risk. Okay, in method of project delivery, the construction manager as constructor, we're going to call it the CMC. The CMC's role is really similar to that of a general contractor. The main difference is that it doesn't come to the scene after the drawings are created and bid on the work. The CMC is hired early to provide pre-construction services. It's going to work with the architect on issues of cost and constructability as the design is being developed. And then once the design is completed, the CMC is going to turn its baseball cap around and it's going to execute the project almost exactly as a general contractor would. And because, as you can see here, the owner is in contract with the architect and the owner is in contract with the constructor, the A201 general conditions applies. If we go to the next slide here, I'm sure this looks even more complicated, but it really isn't. Let's go slow. To the left of the owner's got a contract with the architect. Look under the architect. Architect has got sub-consultant agreements. Nothing complicated there. If you look to the right of the owner, below the owner, you can see that the owner's hired multiple prime contractors. You can see contractor 1, contractor 2, contractor 3. And because the owner has a contract with the architect on one hand and is directly in contract with the constructors, a general conditions document applies. There's a little twist here though, because if you look at the box in the back, it's not the A201 general conditions, it's the A232 general conditions, which we're not going to ever talk about again in this presentation. I want you to be aware though, that in this method of project delivery, where the owner has hired a construction manager as an advisor, merely somebody that is paid a fee in exchange for helping the owner manage the job, there is a fourth stakeholder, right? So it's not just the owner, the architect, and the constructor. The fourth stakeholder is this construction manager as advisor. So we have a different general conditions that acknowledges that there's going to be a role for the CMA. So I don't want you guys to get too confused by this. I just want you to know, at the risk of beating this horse to death, that the A201 general conditions is typically going to apply when the owner is separately in contract with the contractor and the architect on one hand, and in some other more advanced methods of project delivery that are similar to that, there are other general conditions documents that, will be in play here. Same thing here. There is a method of project delivery where there is just interior design and FF&E being provided. And insofar as the owner has hired the architect with one contract to the left, and the owner has hired the contractor to the right, and then there is another stakeholder, an FF&E vendor, the A201 general conditions applies. So again, owners hired the architect, owners hired the contractor, you might be in A201 general conditions land. I'm not going to get too much into integrated project delivery, but there's a bunch of other delivery methods that are really advanced and that I don't think that many of us are likely to work on in our careers. I'll just point out that there also is an A295 general conditions. And so we won't look at any more graphs like that again. But, if I was given this exam and you weren't able to explain that in a design build method of project delivery, the A201 general conditions is irrelevant, and then articulate that in a method of project delivery where the owner is separately contracted with the architect here and the contractor there, that we have to care about the general conditions, that would not be point scoring if you couldn't get that right. That is like the fundamental concept that I want you to take with you. And there's a lot of different things to think about when I am helping my real estate developer clients and my property owner clients select the right, contract forms. And it starts with the things that we have up on the screen here right now. I'm about to hire a bunch of young lawyers right out of law school to try to teach them how to negotiate design and construction contracts. And we're going to start on this pie chart in the upper left-hand corner, talking about project delivery methods at length. I mean, I'm probably going to be working with them for more than a month before we even start looking at contracts, because I need them to understand what's the difference between design, bid, build, design, negotiate, build, design, build, construction manager as advisor, construction manager as constructor, multiple prime contractors. And so whenever you're thinking about what's an appropriate contract form, you always have to start with what's the project delivery method. Then you think about scope and complexity. Are we building a hospital with complicated mechanicals, or are we building an industrial distribution facility that's going to have mechanicals similar to, an air conditioner hanging outside the window of the office? How complicated is it? Kind of a project is it? What's the team like? Is it a team that's worked together a lot in the past and they're comfortable sharing, BIM model elements and working in Revit because they've done it 100 times, or they've never worked together before? And who's the client? Different clients care about different things. Some clients, some owners are most concerned about not exceeding a certain price point. Other owners care more about the quality of the product. Other owners care about the speed of project delivery. And so, at the beginning of a project, obviously not when I'm representing the architect or the contractor, because then I'm sort of responding to another lawyer's ideas about how to set it up. But when I'm lucky enough to represent a real estate developer or an institutional owner of property, and I get to design the project delivery method, I'm thinking about these things before I start thinking about contract form selection. Because you got to balance the need for complexity versus contract protection. I mean, look, there's no virtue in having a really long contract. You know, as a lawyer, I'm not trying to get an A on my paper when I negotiate a contract. I'm trying to get it done in a commercially reasonable way so that my clients can get on with the project. And so if I can right size the contract by having a lighter one that is going to provide appropriate protections, I'm going to go light. But there are times when I need to use a heavier contract. And so if you look to the left, you've got the B series AIA documents, which are owner architect agreements. Some of them are really long, some of them are really short. Same thing over on the right. And so I'm sizing up all the factors on the last slide. Then I'm going to pick which contract documents to use. And we like to talk about the A201 general conditions as having a family of agreements. Okay. And so the B series agreements, again, are the owner architect agreements. And not all of these take the A201. So if you look at the first one, which is underlined, and this is what we're going to mostly talk about today, is the B101, the standard form of owner architect agreement, you could see that it's used with the A201. Okay. But look at the next one down, the B102. This is an owner architect agreement without a predefined scope of services. Do we need the A201 general conditions? Who knows? There's nothing in the B102 that says that the architect is going to be doing anything in CA. So maybe the answer is no. On the B103, on a complex project, the agreement between the owner and the architect, you bet the A201 general conditions matters. But there's a B104 abbreviated owner architect agreement that doesn't use the A201, but it has embedded within it a lot of the verbatim language that the A201 general conditions has. And so it's not the case that every AIA contract document between an owner and an architect is necessarily going to use the A201 general conditions. You have to think about, is the architect going to be doing all of the things that are described in the A201 general conditions that causes the word architect to be listed 300 times inside. And one of the things that you're going to see is that in the owner architect contract and in the general conditions, there's a lot of cross provision referencing, right? So if we were to look at the B101 on the left-hand side, okay, and again, the B101 is kind of the flagship owner architect agreement. It says the architect is not responsible for means and methods. I bet you a lot of you have, just drilled into your brain that that's true. What's the genesis of some of these ideas? You're looking at it right here. And if you slide over to the right-hand side and you look at the A201 general conditions, it is going to contain some of the same concepts. So the B101 and the A201, they work together hand in glove. They're meant to be used together. I'll often be involved in a project and I'll ask an owner or an architect, hey, give me your owner architect agreement. Let me see it. I'll only get the B101. And you know what? I'll say, where's your A201? They're like, there wasn't one on this project. And I say, okay, that's a mistake, right? Because even if you never negotiated one, even if there's not one associated with the project, if you use the B101, it automatically defaults into the standard off-the-shelf A201. Right? The A201 is not a document that requires a signature. It's technically not part of the architect's agreement, although it very much binds the architect for reasons that we will discuss. But the B101, it points to the A201 general conditions. It incorporates it by reference, okay? And so let's talk for a second about this idea that the general conditions is not part of the owner architect agreement, that it binds the architect, And, the general conditions is technically part of the contract documents on a traditional project. You can see here, the owner architect agreement typically is going to define what are the capital C, capital D contract documents. And it's typically change orders and drawings and specifications in the general conditions. What's the reason why we say the A201 general conditions is part of the owner contractor agreement? This is really simple. It's just a question of timing, right? Typically, in most construction projects where the owner is going to separately hire the architect on one hand and then the contractor, the architect is going to get hired first because the architect is going to do its design first. And only maybe 9 months or a year later are the drawings going to go out to bid to the GC. So it's the blinding flash of the obvious that the owner and the architect can't go negotiating changes to the A201 general conditions because they can't go and bind some contractor that hasn't even been identified yet, right? It's a matter of timing. The general conditions winds up being a part of the owner contractor agreement only because of timing, only because it's not until the contractor is identified and gets under contract with the owner that you are able to begin to have a dialogue among the owner, the architect, and the contractor about how the off-the-shelf A201 general conditions document might be modified. That's the reason why whenever I negotiate a B101 owner-architect agreement, even though the general conditions is very much a part of that document in terms of setting out the architect's rights and obligations, I never adjust the A201, right? When I negotiate an owner-architect agreement, we just worry about the owner-architect agreement. We refer to the standard off-the-shelf A201 general conditions, and we leave it at that until there's a contractor in the mix, okay? So let's look again at some of these cross provision that might make this a little more easy to understand. Look on the left. In the B101, the standard owner architect agreement at section 36.1.1, it says that the architect shall provide CA as set forth in the general conditions. This is a way of basically saying that, hey, architect, you're agreeing to do all the architect-y kind of things that are assigned as the role of the architect in the general conditions. And you've got similar language in the general conditions itself. This section 3.6, specifically 3.6.1.1, is kind of that contractual hook where the owner and architect agree. We've got our contract that sets out what the fee for design is, you know, what the architect is going to do. And yeah, oh, by the way, architect, you're going to do all the architect-y things that are described in the general conditions. Okay. Some of you are probably thinking, well, wait a minute. What happens if the owner hires the architect, they sign a B101 standard owner architect agreement, and they wait 9 months or a year until the bidding happens and a contractor emerges as the winner? And what happens if the owner and the contractor at that time modify the A201 general conditions, right? Like Jeremy just said that it references architect 300 times in the general conditions. It doesn't really seem fair for the owner and the contractor to get to change that, right? So what if the owner and the contractor would have put absurd language in there that said that the architect is responsible for means and methods, or the architect is responsible for site safety? Well, the answer is obvious based on this slide, because if you were to look at the basic owner architect agreement, the B101, it says that if the owner and the contractor later modify the A201, those modifications are of no impact whatsoever on the architect unless the architect agrees to those changes, okay? So what the architect is agreeing to do in most every AIA contract document where the general conditions applies is to do the tasks assigned to the architect in the unmodified version of the general conditions, the one that comes right off the shelf, the one that Paul circulated to all you by email. So let's take a look real quick now at this B101 owner architect agreement. I know that it's not the subject of this discussion, but it's impossible for us to talk about the general conditions unless we very lightly touch upon the owner's agreement with the architect and the owner's agreement with the contractor that puts the general conditions at the heart of it all. So, you know, what is the architect's basic job in the B101? It's to provide its contractual scope of work. There's nothing, shocking about it. There's a definition of the architect's services, what any architect would be expected to do on any design project. We got SD and DD and permit set and bidding and, construction documents and CA, and there's an assumption that the architect is going to hire the, MEPFP and structural, sub-consultants, which isn't always true and may require some modification. And the architect's traditional services, right? 5 phases, SD, DD, CDs, nothing shocking there in the 101 is what we're all familiar with. We're going to be focused today on the construction phase because that's really what the general conditions is all about, okay? And as we already looked at on another slide, the B101 says it assumes that the architect is going to provide CA. That's not always a good assumption, right? There are times when the architect is only going to design, and when there's a permit and the drawings are stamped and sealed, they're out, right? And if that's the case, the B101's got to be modified here, right? We could say the architect shall not provide CA. That's a perfectly fine way of modifying the owner-architect agreement to knock out the general conditions document, okay? Now, let's shift gears a little bit here, and let's talk a little bit more about this topic that we're on today, this general conditions document, okay? And we are not going to review this exhaustively because I know it would go in one ear and out the other. And that's the reason for this comprehensive slide deck, which I hope will serve as notes for you. But if you were to look at your table of contents in the first pages of the general conditions, you can see that it is divided up into 15 articles. And, you can see here that there are very important things in the general conditions document that we couldn't live without. For example, Article 7, change orders. Article 8, schedule and delay. Article 9, payments, okay? Article 11, insurance, all right? Those things are not necessarily completely addressed in the underlying agreement between the owner and the architect on one hand, and the owner and the contractor on the other hand. Those other agreements, the B101 owner-architect agreement and the A101 owner-contractor agreement, those are kind of the business deal documents. Those are the documents which say, this is the kind of project and this is how long you have to get it done and this is how much I'm going to pay you for it. They embody the business deal, all right? But it's an incomplete thought because without the A201 general conditions to bridge the gap on all these important things, Article 9, pay apps are going to be submitted by the GC to the architect. What's the architect going to do? Are they going to certify the pay application, or are they going to tell the owner, I can't certify all of it? Or are they going to tell the owner, don't pay? Are they going to say substantial completion has been reached or not? That stuff is in the general conditions, which is the reason why I believe, in my humble opinion, that you are talking about now the most important contract document on United States private construction projects where it applies. Again, doesn't apply to a design build project, right? Because the owner's not separately hired the architect and the contractor. It's only hired the design builder, right? That one throat to choke. So I want you to look at the table of contents. And I want you to take away that there are very important things in here that we cannot live without to have a complete contractual understanding among the parties. And I also want you to see that it would be an enormous mistake for an owner to only read Article 2 and to say, I only need to care about Article 2 because that's where it talks about owner, right? And it would be a huge mistake for the GC to say, I don't need to read anything other than Article 3 because that's about the contractor. Same thing for the architect in Article 4. If you were to search on the word architect or owner or contractor, you would see those words scattered throughout this whole document. All right, so that is what we're talking about here, okay? And we've said that the A201 is part of the owner contractor agreement. I've discussed that that is where the GC perhaps begrudgingly accepts the architect's role as kind of a protector of the owner. It's going to call out a payout that shouldn't be approved. It's going to call out bad construction work if they observe it in the site, and the A201 specifies the architect's role in acting on behalf of the owner, but it's really important to understand that that role is not unlimited. The architect is not a general agent of the owner. The architect is not able to go and willy-nilly bind the owner to whatever it is the architect thinks is right. The architect is only empowered to act on behalf of the owner to the extent the general conditions so empowers the architect. Okay. So we're not the general agent for everything. The architect can't bind the owner for everything, but it does say the architect more than 300 times in this document. So, there is a, there is a little push and pull between the idea that the architect has this huge role, but it's limited. And so certainly if you're an architect, but really if you're anybody else involved in a project, understanding the role of all the parties, not just the architect, but the owner and the contractor as well, it's really critical. And that's the whole point behind this general conditions document. Now, the last bullet point on the screen here, I would just point out that, some people feel like there's a moral hazard here. If the architect is going to be the arbiter of, problems between the owner and the GC, many people would say, well, who's the architect going to side with, right? The architect knows what side its bread is buttered on. It's going to dance, with the person that brought him to the dance. Who brought him to the dance? The owner, right? And so some people have, raised the concern that there's a moral hazard here, that the architect is always going to side with the owner. I think that the AIA has done a great job to try to make this document, fairly up the middle for all the various parties, right? Of course, no GC would ever agree to use this document if it wasn't reasonably impartial. But I do want to point out that the AIA ethical code requires architects to act impartially. So, an architect is not allowed to just be in the best pocket of the owner and always interpret everything in the way that's most favorable to the owner. And there's a bunch of specific provisions in the general conditions that carry forward that idea. So now we're going to shift gears and we're going to talk about the first specific requirement that you will find, in this presentation that needs to be carried out, during CA. And so this is the part now that I hope that I've not totally bored you, and I hope that I've beaten the horse to death about which projects you need to care about this document on and which ones you don't. I hope that you can see how, this document sits between the relationship of the owner, the architect, and the contractor. And so now we're going to shift gears and we're going to spend the rest of the time in this presentation talking about specific provisions in the general conditions. And so if this is relevant to the CT exam, which I assume it is, paying attention, to the whole document, good idea, but certainly understanding, some of these specific sections. If I was writing the exam, which I don't, and I haven't even seen it, so I can't guarantee what's on your test, but to me, this is the stuff that's extremely important and foundational for everybody to understand. So the first specific obligation that's discussed is site visits, okay? And if you look at the A201 general conditions in section 4.2.2, it says that the architect is going to come to the site at intervals appropriate to the stage of construction, which is pretty open-ended. As a lawyer who likes a little more of a definitive answer than that, what does that mean? If it's a really complicated part of the project, does that mean there's got to be there every day? Or, does that mean that they only need to be there once a month or less? And the A201 says that the architect should come when they should come, unless there is a specific agreement between the owner and the architect about how many site visits there will be. And of course, the B101 owner-architect agreement gives the owner and the architect the ability to say, we're going to come out once a month during CA and that's it. And so the B101 language will trump that there, right? We've got similar language in the B101 about site visits, but the owner and the architect, as part of their business deal based on fee and level of service, can cap the number of site visits. That's something that is done in the B101, and it is relevant to what's in the A201 general conditions. Continuing on, the subject of site visits, I think it's really important for you to see all this really loose language in here. What the architect is asked to do, because site visits by architects are not inspections. That's generally thought of as a dirty word, right? Because an inspection is you're looking under a microscope at every little bit of construction. But what we all know, even if you have an architect making site observations once a week during construction, the vast majority of conditions are going to get built. Walls are going to get sealed up, before the architect necessarily has a chance to see what is, in the wall before it is sealed up. The architect is not paid to watch the contractor drive every nail. When I'm negotiating a contract and I represent the architect, and there's an owner that's trying to change the language here, which I'm going to go over in a second on the slide, and make it like the architect is the guarantor of perfect construction, I tell the architect, tell your owner client that you're increasing your fee by 25 times if they want you to watch every nail being driven. Because if the owner wants an architect to station 5 or 6 observers on site every day, fine. But if that's not going to happen, if the architect is only occasionally going to come to the site and make observations, what's the appropriate standard? Well, that's what you see on the screen right here. The A201 at section 4.2.2 creates an appropriately loose standard for the architect. It says that the architect is going to come to the site to become generally familiar with the progress of the work. Not familiar, because that would imply that they have to know everything about the construction. They don't have to know everything. They have to become generally familiar, because that's all you can do if you're only occasionally on site, right? And again, that word general is used again because the architect is to determine in general if the work is being performed in the right way. And so all these instances of the word in general and all this loose language around site visits is because the architect is not going to watch every nail being driven. And if you look on the screen, the second bullet point there, what I underlined is important: when completed, because the architect is not there looking at everything on site, right? For those of you who are architects, you know that when you go to the site, temporary conditions, how the tilt-up wall is being tilted up, how the trench is being shored, is it safe? Those are means and methods of construction. And an architect is supposed to look straight through those temporary conditions as if they don't exist, because it's not their job to think about them. What an architect needs to do during site observations is to think about, is the work progressing in a way that when the job is over, you can see the words when completed here. They come to the site to determine in general if the work is being performed in a manner that indicates that when the work is done, in other words, when we have the final product that is the architect's design intent, will that be in accordance with the contract documents? So that when completed language is a nod in the direction of the architect isn't looking at temporary conditions or means and methods or safety. They're just looking with X-ray vision at, is their design intent being carried forward in the way the contract documents envision. And, the architect is not going to be responsible for site safety unless they do something really stupid and assume responsibility for that, which I'll talk about in a second. Sticking with this idea of site visits, in addition to keeping the the owner reasonably informed, right? Not informed. There's more loose language here. Reasonably informed, because the architect is not there every day. In addition to keeping the architect reasonably informed about the progress and the quality of the work, the architect must. This is not optional, okay? This is a requirement under the general conditions. It must report to the owner known deviations from the contract documents and from the most recent schedule. Now, it doesn't say deviations, it says known deviations, right? Because how can an architect keep an owner informed about unknown deviations, right? It can only report on things it knows about, okay? And there's more loose language. Defects and deficiencies observed in the work. It doesn't say that it has to keep the owner totally informed about all deviations, from the contract documents and deficiencies. It's got all this loose language. It's reasonably informed. It's known deviations. It's observed defects and deficiencies, okay? And there's no obligation here for the architect to provide a written record, right? I'm going to get into in a little while when the architect needs to produce a writing, when they don't. There's nothing here that says that site observations have to be reported back to the owner in writing. But it's still a pretty good idea for a design firm, because you do have an obligation to keep the owner reasonably informed. And if you ever get into a disagreement over whether the architect did it right or wrong, if everything is verbal, it's going to be, a big he said, she said. Some design firms standard form report document for site visits, is something that they use. And if they have such a document, it should very closely tailor, its requirements to the B101 and the A201 that we are talking about here. Now, we don't like to use the word inspect, ever. I try to strike it out of owner architect agreements whenever I can, because again, it implies, maybe that the architect is watching every nail being driven, which, is not true. There are a few occasions where the word inspection is used, okay? And another instance where the A201 empowers the architect to act as the owner's limited agent, okay, is making inspections to determine the date of substantial completion and final completion. In another instance where the A201 empowers the architect to act as the owner's agent is to reject work which is non-conforming. The architect to order tests when necessary, right? It might be, did the concrete sufficiently dry, before follow-on work was installed atop of it. Well, if the architect is walking around out there and has any concerns about that, if the architect doesn't exercise its duty to order tests on, the concrete, the architect could find itself, in a little bit of trouble. In addition to inspections, an architect can be asked to provide interpretations of the contract documents, which, is a really logical role for an architect, right? I mean, the architect is in on the ground floor of the project. They provided the design. They do, construction administration. So, when the owner and the contract get into a disagreement about what the contract documents require, it is, at least in the first instance in the A201 general conditions, the notion is that the owner and the contractor come to the architect for an interpretation. Okay, and so if you look at these sections here, if the owner or the contractor asks the architect to do it, they shall, not might if they feel like it, they shall interpret and decide matters about what the contract documents require. And again, we talked earlier about this moral hazard, right? Is the architect always going to side with the owner? Because that's the architect's client. And as you can see this language here in 4.2.12, it says that when the architect is serving this important role, it has to endeavor to secure faithful performance by both parties, meaning that they need to play it straight and interpret the contract documents right up the middle. And you're not allowed to show partiality if you're the architect to either party under this document. And there's actually a safe harbor, okay? there's language in the A201 which says that if the architect interprets the contract documents in good faith, it is not responsible for those interpretations, sub to the big caveat that as long as they don't breach their contract or violate the standard of care. And so the AIA has done what it can over the years to try to make sure that the architect is not in the best pocket of the owner, even though that's the architect's client. Let's talk about some further specific requirements, and let's talk about coordination between the A201 general conditions and the B101 owner architect agreement. Let's look at RFIs. So the architect shall review and respond to RFIs in writing. This is one of the times where the architect has to produce a writing, okay, within the time limits agreed upon. And, sometimes you'll see a contract that says like the architect's got a week or two to respond. I hope that that's not the case. I generally dislike that kind of language, but there might be a period of time where they have to respond by, or in the event that there is no such, architect has got to turn RFIs in 5 business days or something like that with reasonable promptness. Okay. And if you look at the B101, there is the possibility that an architect might be entitled to additional compensation in answering RFIs. It throws open the possibility of where the contractor, if they carefully reviewed the contract documents, they could have answered their own question. If the architect has got to respond to an RFI that's a knucklehead RFI, there's the potential for the architect to raise their hand and to ask for additional compensation. Let's talk about changes in the work. There's a concept that not many people are familiar with. We all know what a change order is, right? A change order is when the owner and the the owner and the contractor have agreed on a change. And maybe the price goes up, maybe it goes down, maybe the contract time goes up and goes down. The point is the owner and the contractor agree on what the change should be and whether the contract sum and contract time has to be adjusted. But there's another lesser known concept called a construction change directive, which is really important because it prevents a contractor from getting an owner over a barrel if the contractor wants a change order, right? Every single person who's on this call right now has been involved in projects where there are disputed change orders. And if the owner can't get the GC to do the work of the change order until there's agreement on price and schedule, what's going to happen? Well, the GC is going to have the owner over a barrel, and the owner is going to have the terrible decision to make of either sign a change order that gives the GC time and money they're not entitled to, or have their project grind to a halt. Well, the construction change directives concept helps the owner get around that. The CCD, construction change directive, basically says that if the contractor and the owner can't agree on a change order, the owner is allowed to essentially say, hey, GC, go forth and do the work, and we will figure out how you are, whether you're going to get more time or money later. And if you look in the A201, there's a whole lot of language under this construction change directive concept, CCD, about how pricing is agreed upon so that the contractor doesn't wind up having to do work that they don't get compensated for. And, in addition to those two types of changes, the familiar change order, the somewhat less familiar CCD, construction change directive, the architect is also empowered in the general conditions to order minor changes. And a lot of owners don't like that, but the off-the-shelf A201 general conditions document defines a minor change as one where there's no change in the price to the owner or the contract time. And so it might just be the paint color changed or something like that, minor changes. There's a lot in this document about payments. And here is one of the rare places where there's a really legally operative, scary kind of strong word used, certify, right? We We talk about site observations, not site inspections, right? Because reasons I've already discussed. And boy, certifying a payment application, that really sounds like you're shooting the moon. That sounds like it's at a high level. And that is really the case, because the architect's duty to review and to certify the amounts due to the contractor and then to issue certificates for payment is a really weighty obligation. And it's one of the trade-offs. If I've got an owner that is only an occasional consumer of design and construction services, maybe does a project every 10 years, does not have the in-house staff to be able to say, wait a minute, you're not entitled to the payment that you're asked for, GC. What's an owner to do? Well, they separately hire the architect under a set of contracts where the A201 general conditions is in play. And the owner gets to look to the architect to protect it, to say, I know, owner, you might not be able to tell that they're looking for 33% payment, but only 30% of the work is done, but I'm the architect and I do know. So an architect that does not understand that they have this obligation to be very thoughtful about reviewing and certifying these payment applications can find themselves on the wrong side of a lawsuit from an owner that feels like the architect kind of rubber stamped the pay apps and allowed the GC to get more money that they were entitled to. And then, the owner's out over its skis on payments. Of course, an architect doesn't watch every nail driven, so they can't 100% guarantee that the work is as the contractor represents. We've got a little bit more loose language in the A201 in section 942, which says that when the architect certifies the pay app, that is a representation to the owner. Not that the work is as the contractor says it is. There's a big qualifier, which I've underlined, that the work has progressed, to the point that the GC says to the best of the architect's knowledge, information, and belief. So again, that is architect-sided wiggle room that is going to lower the level of obligation that an architect has. An architect is not a guarantor of perfect construction, right? And that's one of the points that this document tries to drive home. There's an important role for the architect to play in keeping an eye on the contractor to protect the owner. But unless the owner is going to pay the architect to watch every nail being driven and be there every day with a phalanx of site observers, there needs to be some wiggle room for the architect, or it's just plain unfair for the architect. Sticking with the topic of payments, it's really important for everyone on this call to understand that the act of the architect certifying the payment application, it's really important. It's playing with live ammunition. It's a legally operative act, because when an architect issues a certificate for payment, that is the thing which triggers the owner's obligation to pay. Okay, so this is not a nicety, where maybe the architect has to do it, maybe they don't. At least in the way that the A201 general conditions is written up, this is mandatory. Now, we all know, everybody on this call, that a lot of people don't understand the general conditions. They may not know that it's relevant to their project. They may never look at it. Owner might not know, architect might not know, GC might not know, or maybe they knew and it got shoved in a drawer and somebody forgot about it, right? On most projects, it's not the case that everybody involved is going to instinctively know where in this document to go to understand all this stuff. So I don't want to say that some of this stuff is wishful thinking, but it is to some extent, right? Because owners will often make payments to contractors without the architect issuing a certificate. And if the owner does that, it does that in its peril, possibly. And, there's other things here that are a little bit wishful thinking. Like if you look at the last bullet point on the slide here, The owner is required to notify the architect when payment is made to the contractor. And I mean, for those of you who are involved in design and construction projects right now, I don't know that the owner or its title insurer that's making payments remembers to tell the architect when the check is stroked to the GC. So, there's some stuff in here that, it often doesn't happen even on projects where people are pretty attuned to these obligations. But I can tell you that when the project goes off the rails and people lawyer up, which is something that I really dislike. I'm a dispute avoider. I'm always trying to make sure we never wind up in court. 95% plus of my work is keeping the genie in the bottle and stamping out disputes before they ever arise. But when I'm not able to do that, and when all the parties lawyer up, you can bet that the lawyer that is going to want to come and sue you or your employer and argue that you, the person who's on this call, did something wrong, they're not going to have any trouble finding the A201 general conditions, and they're going to read it and they are going to say, why didn't you do that which you were obligated to do? And so, I don't want to scare you, but if you're going to be involved in design and construction projects, and if you're either the owner, the architect, or the contractor, and the A201 general conditions is in play, if you're on this call, your instinct for self-preservation should kick in sometime about now, and you should say, this is a long, boring document, but it's worth me knowing what my obligations are, because I don't want anybody to ever come at me in a lawsuit and say that I didn't do what I said I was going to do in the project. So let's stick with payments for a little while longer here. So what happens if the architect doesn't certify a payment application? Well, the answer is that the contractor can stop work. I said that this document is a little bit of a trade-off. It's a compromise between the three principal parties, the owner, the architect, and the contractor. This is one of the contractor-sided compromises. The architect has got to take action within 7 days, at least under the standard off-the-shelf version of the A201 general conditions. Okay. And so, because it wouldn't be fair to a GC for an architect to sit on the forever. And what can a GC do if an architect doesn't take action in 7 days? Well, the GC could stop work. Okay. And trust me, if you're the architect, you do not want to be in the position of having to tell the owner that the job stopped because the pay app sat in your email inbox, right? Because if that happens, if you read, to the bottom of this slide here, the contract time, meaning how much time the GC has to complete the work, shall be adjusted. Not might be adjusted, shall be adjusted. And the contract sum, the amount of money that the contractor is to be paid, shall be adjusted. Shall is as declarative of a word as lawyers have thought up yet. Believe me, you do not want to be the architect having to tell the owner of the job, stopped, and that the owner's got to pay more money and they're going to get their project later because the architect was lackadaisical and they didn't understand their obligation to quickly take action on the payment application. So here's an idea for you architects out there that have your heart beating, quickly at this point. Adopt a triage process, right? It doesn't have to be, the project, manager or the owner of the design firm that, has to look at the pay app. Just have anybody knowledgeable, any mid-level, employee at the architect, have them take a quick peek as soon as the pay app comes in. Are there any substantial deviations in that document from what that architect employee thinks is right? Would the architect say, wait a minute, we're nowhere near halfway through the plumbing rough in. Like, what's this request for payment for 50% of that, or, there isn't even a window out there, how could the contractor be seeking payment for all this money? Have somebody just take a quick look, do a gut check, because you can stop the 7-day time period with a quick response. So if you're an architect, it pays to know what this document says. it's got the word architect in it more than 300 times, and people that don't understand it, are blissfully ignorant at their own risk. Again, the architect is empowered to protect the owner. And one of the real important ways that the architect is empowered to do that is to either withhold a payment certification or, and this might surprise some of you, to nullify one that was issued in prior months. Okay. The general condition says the architect may withhold certifying a pay application to the extent that it's reasonably necessary to protect the owner. And it goes on to say that the architect can nullify in whole, which is big, or in part, a pay app from a month or two prior, if necessary to protect the owner from some financial loss for which the contractor is responsible. And then when the conditions that would cause an architect to do that are removed, then at some point, 90 days from now, whatever, the concrete was too wet, it didn't cure properly, the architect ordered a test, it's no good, it's got to be torn out. The architect nullifies the pay app from 2 months ago, GC repours the slab, test comes in good. 2-3 months from now, after the losses are kind of adjusted, then the architect reissues a new certification for whatever the contractor has already been paid. And man, I'm telling you, if you're an architect and you don't understand this is your job, watch out, because whatever lawyer sues you and says that you allowed too much of the owner's money to wind up in the contractor's pocket, that lawyer is not going to struggle to find this document. So this is an important document for those of you who are interested in self-preservation. But it would be unfair for this document to not at least give the architect some guidance about when it is required to withhold or to nullify certifying, pay applications. And it's very clear in section 9.5.1, defective work unremedied. Reasonable evidence that some third party is going to file a claim. Maybe it's a lien. What if a contractor's not paying its subcontractors, right? Or what happens if, because of some problem with the the work on the project, whatever the owners agreed to pay is not going to be enough to get the job done, right? Or what happens if there's damage to the owner? Okay. Or what if there's evidence that the project is not going to come in on schedule? Or repeated failure of the GC to carry out the work in accordance with the contract documents, and it carries on. Or actually, I'll stop there and go back and make the point before I move on, that this is why I say that this document is not just some egghead thing for lawyers to care about. This is a practical desk reference for project managers. If you pointed out defective work at the last site observation, didn't get remedied, here's the next pay app from the GC. What's an architect to do? Well, pull out your A201 and read what it says about what you're required to do as the architect. What if you're the architect and you're starting to get calls from subs saying, hey, I'm not getting paid? What is an architect supposed to do? Pull out the A201 general conditions, pull out the desk reference, and look it up. The document is not comprehensive. It's not going to deal with every situation, but boy, oh boy, on every project where the A201 general conditions is in play, there really ought to be somebody on behalf of the owner and somebody on behalf of the contractor and somebody on behalf of the architect that knows this stuff inside and out. Because if you just go and certify a pay app, even though the defective work has not been fixed, because contracts are boring and I can't be bothered to read it, and I don't know what the general conditions are about, and it's too long, and there wasn't one on this project, or it's somebody else's job, you're inviting a claim. And as somebody who detests litigation and thinks that it is, one of the worst things ever invented by, mankind. And mind you, I've been litigating for 20 years and I am up to my eyeballs in litigation right now. I think it's terrible. It destroys relationships. It's not good for anybody. Let me help you not invite a lawsuit by drilling home the point that you have to understand what's in this contract document. That's why it's part of the CDT course, is because if you hate contracts and you went to be a GC because you just want to pour concrete, and if you went to architecture school because you just want to design and you can't be bothered with contracts, that's a bad idea. So let people like me help people like you stay out of disputes by understanding how to deal yourself a good set of facts on the project, to create a good written record for yourself so that you don't find yourself pulled into an avoidable lawsuit. Let's move on to the next specific requirement. It is the right and the obligation at certain times for the architect to protect the owner. All right. And this is another instance where the A201 is the project manager's desk reference for those projects where it applies. The architect absolutely has got obligations if the contractor starts to make noise about finding concealed or unknown conditions. Maybe it's behind a wall in a building that's being renovated. Maybe it's below grade. What is the architect's obligation? If the contractor encounters a condition that is subsurface or concealed, right? Concealed might not be subsurface, it might be in a wall, that differ materially from what the contractor expected, the contractor must notify the owner and the architect, right? And then what is the architect's obligation? If the GC starts to make that noise, get somebody out there fast to conduct a prompt investigation. Must is another declarative word like shall. The contractor must notify the owner and the architect. The architect must conduct a prompt investigation. And this is another instance where the architect is required to create a writing on its results, right? Because if the architect's investigation, and again, this slide right here is summarizing general conditions provisions that I've cited in the last slide. If the architect's investigation, through it, it determines that the conditions do differ materially than indicated in the contract documents or what the contractor should reasonably expect, and it's going to increase or decrease how much time it's going to take the contractor to do the work or how much money it's going to cost the contractor to execute the work, then the architect is supposed to recommend to the owner and the contractor, this seems like a reasonable amount of additional time, and this seems like a reasonable additional amount of money, right? This is the architect's job. And if the architect finds that those conditions don't differ materially, and there's no change that's justified in the contract sum or the contract time, then the architect needs to promptly notify the owner and the contractor in writing. Again, this is one of the instances where the architect has to produce a writing. They don't have to for site observations, even though it's a really good idea. But this is one of those times where it would be inexcusable for an architect to not create that writing. And so now we're going to set some of that stuff aside, and we're going to go on a little tangent here. I'm mindful of the fact that we're already well into this presentation. I'm going to try to land this ship as quickly as possible here so you all can get on with your evening. But I want to talk with you a little bit about the concept of initial decision maker, because I've already, probably, beaten to death the idea that the architect has certain obligations to protect the owner, but there is actually a higher level of responsibility that the architect will sometimes have than just interpreting the meaning of the contract documents and, passing on, low level disputes between the owner and the contractor and deciding whether or not unknown condition justifies more time or more money. There's a whole section at the back of the A201 general conditions, which says that there's this thing on the project called the initial decision maker. And I'll give you a little bit of history here real quick. You can kind of avert your eyes if you wish from the slide deck, because I'm going to go on a slight tangent for a second here. When the AIA introduced the 2007 version of the general conditions, right? So not the one that applies now, the 2017 version, but the one before that, the 2007 version, we saw for the first time this initial decision maker term. But it isn't really a substantive change from the 13th iteration of the A201 general conditions that dates back to 1997. We just have a new term. So if you go back to the 1997 version of the general conditions, if there was a dispute between the owner and the contractor, they were required to submit the claim to the architect, and the architect renders a decision. And if either party, the owner or the contractor, disagrees with what the architect has to say, the owner or the contractor can initiate formal dispute resolution. They can proceed on to mediation or arbitration or litigation. Okay. And again, the architect has this ethical obligation to render an impartial decision in good faith. But when we got to 2007, members of the AIA Contract Documents Committee and liaisons to the AIA Contract Documents Committee like me, the stuff that we get to think about, is we had to come up with a new term in 2007 because we needed to satisfy concerns raised by general contractors. And that is where we got this new term, initial decision maker. So what came out in the 2007 version of the general conditions is very similar to what is in the current version, right? And if you go back to the slide deck right now, what the general condition says, that unless the owner and the contractor pick somebody else, the architect is going to serve in this role as initial decision maker, right? So if we go back to 1997, it doesn't say there's an initial decision maker. It just says the architect's going to decide. Contractors didn't like that. Some owners even wanted to leave open the possibility that we'll have a different initial decision maker. So we have a new term in 2007, the IDM. And in initial decision, the IDM passing on the dispute is a condition precedent. That's a big lawyerly term that says that it's a necessary condition. It's a requirement before the owner and the contractor are allowed to take their disputes to the next level and do the arbitration, mediation, litigation thing. Okay. And if you look at the B101, which I've talked about at the bottom of the slide deck here, it says that unless the owner and the contractor pick somebody else, by default, it's the architect. And that role as the IDM is a basic service for the architect. And the only time that it wouldn't be a basic service is if the owner and the contractor pick somebody else to be the IDM, right? Maybe they got a construction manager or something like that. If the owner and the contractor want to pick somebody else as the IDM, it's an additional service for the architect to help the IDM out, right? And it makes a lot of sense, right? Because if an architect is asked to render a decision about their design intent, they don't need to think too hard. It's in their brain. They just say, this is what it is. But if they got to struggle to try to help some third party understand what the design intent is, and they got to go through all this rigmarole to help some other IDM get up to speed, it's an additional service. The owner is going to pay for that when the architect asks for an add service. And so the IDM, whether it's an architect or somebody else, is required to review claims, and a capital C for claims. There's a definition in the A201 about what kind of claim we're talking about. It's not every change order. It's a higher level claim. The IDM, whether it's the architect or somebody else, has to render a decision within 10 days. Okay. And again, this is one of the other instances where there's a requirement for the architect, if it's the IDM, to act in writing. So obviously architects have a role in submittal reviews. Something that is a little followed, but really could be beneficial to a lot of parties is the idea in the A201 that the contractor must prepare and submit a submittal schedule. Okay. And, give it to the architect to, review and approve, right? So they're going to say, you can expect our submittal on framing about here, and you can expect our submittal on, the elevator about here. And, if an architect is smart enough to understand that this is a requirement, they can say, hey, our contractor, I'm not reviewing any submittals until we agree on the schedule. It's generally not something that every architect thinks about doing. But when the architect reviews the submittals in accordance with the approved submittal schedule, meaning something that the architect has agreed to, it does so, and again, this is limiting language, not to ensure that the submittal is perfect, but for the very limited purpose of just checking to make sure whether it's consistent with the design intent expressed in the CDs, okay? And in the event that there is no submittal schedule, then what the general condition says is the architects got to do it with a reasonable promptness. And owners and contractors want submittals to be reviewed very quickly, and some would argue that 5 business days is a fair amount of time, and some would say less, some would say more. All that I would say is that you get a complicated submittal on Christmas Eve, you're going to have a heck of a time if you're an architect getting that thing reviewed by New Year's Day, especially if it's an elevator and you got to talk to a lighting consultant and you got to talk about, some kind of a millwork fabricator, and you got to have the, plumbing, engineer think about the sump. Good luck getting that reviewed between Christmas Eve and New Year's Day. So, it can be very helpful for everybody to have a submittal schedule. And it's something that I'm a big fan of, even though I would say that almost universally, no one remembers to do that. The owner, the architect, and the contractor don't really do that. And again, there's a bunch of limiting language here, okay, that recognizes that the architect is not the guarantor of perfect construction. We talked about this with site observations and the loose language, the like in general and that sort of thing. This is the same kind of idea here, because architects don't review submittals to determine the accuracy and completeness or substantiating installation instructions or for the performance of equipment. I mean, right? If you have to comply with the ADA and, the shower knob says that it's ADA compliant, how is an architect going to know whether it requires tight pinching or grasping unless they mock up the shower and turn the thing to see whether, the tight pinching or grasping is required? So it's not at that level. The review is not at all about safety precautions. And it's not, so for example, or means and methods. So, what should an architect do if they get a submittal that says how the GC is going to torque the bolt on the crane that they're going to use to lift the beams? Well, a smart architect is not going to approve it or reject it. Smart architect is going to say, look, this is means and methods. This is nothing with my design intent. Thank you for sending it to me. I'm going to stick it in my file, but I'm not going to approve it. I'm not going to reject it. I'm not going to pass on it at all. I'm going to just say, thanks for sending it to me. And I'm not even going to read it or give you any opinions on it, because it doesn't matter whether an architect is given a submittal that gets into safety or means and methods. You're not supposed to, as an architect, get into those things. And there's other limiting language about how, if you approve a specific item, you don't necessarily approve the whole assembly. And so, when, an architect is at the early stage of a project, what are some of their obligations? Number one, to identify what submittals they want. Number two, to ask for the submittal schedule. Okay. And so if you look at the first bullet point on the screen, the contractors needs to review the CDs to figure out what submittals are required and submit it to the architect as agreed. And when the GC submits a submittal to the architect, it, because of the compromise language in the A201, is representing that it has reviewed and approved the submittal, right? So it's not just passing along something from a trade that they didn't look at. somebody at the GC's got to review and approve it. They've got to, determine and verify materials, field measurements, data, or, that either they have or they will do so if it's relevant to the submittal, and that they've checked and coordinated the information contained in the submittal with the requirements set out in the contract documents. So, this is, an example of where there's compromise, right? And so let's talk about what the architect is not responsible for, okay? The contractor, the architect, it says very clear in the owner-architect agreement, the B101, the architect is not the guarantor of perfect construction. They're not responsible for the contractor's failure to perform the work in accordance with the contract documents. They're not responsible for the means and methods and safety precautions associated with the work. But let's talk about some exceptions where an architect can step in it and make themselves responsible for these things, right? If the CDs, which includes the drawings and the specs, give specific instructions about means and methods, okay, then what the contractor needs to do is to take a look at that and see whether they think it's safe. So let's take this out of the abstract and talk about a concrete example. If there isn't for the architect to specify means and methods and safety, if the architect says, and this would be a really bad idea, so I'm not advocating this, but if the architect says to the G, and by the way, this is a little bit of a ridiculous example, so, and I recognize that, but say the architect says, hey, GC, this spec section says that I want you to build the roof in its entirety on the ground, and then I want you to hoist it to the top of the building using a specific kind of crane. That would be an example of the architect undertaking responsibility for means and methods and site safety beyond which is necessary. And but if they were to do something like that, bullet point here says contractors got to see whether they think they can do it safely. And if the contractor determines that they can't do it safely, they got to let the owner and the architect know and propose an alternative. And the architect is going to say, all right, well, you're going to get the same roof up there in another way. I'm not talking about means and methods or safety. I just want to know whether the way the contractor proposes to do it is going to get that thing on the final product, the way they want it. Okay. And unless the architect says, no, if we don't build it on the ground and lift it up with a specific crane, my design intent's not going to be carried out, then the contractor gets to have it, their way. And so, that's something else to bear in mind. The last few slides of this deck are a bunch of fluff. So we're getting near the end of what I'm really going to cover here. I hope to be out in 3 minutes or so. There's a section in here that talks about the quality of the contract documents, right? And it says that the goal here is to include everything that's necessary for completion of the work, and one drawing is complementary to another, and so if I got so say for example, I got a detail that shows for ADA reasons, the center line of the toilet is 16 to 18 inches off the wall, and every tier of the building is detailed out that way, but except for that one floor where they forgot that 16 to 18 inch detail, a contractor can't say, well, what was I supposed to think? I thought that you wanted this one floor to have a toilet that had a different center line. No, what this says here on the screen is that, what's required by one is as binding as if it shall be required by all. The GC's got to realize that if somebody forgot a dimension or something like that, their eyes have to be connected to their brain. They don't get a free pass. You got to kind of review the totality of it. And you got to do what's necessary to comply with the contract documents and what's reasonably inferable from what you see in there. So if every toilet is detailed 16 to 18 inches off the wall for one floor, GC can't say, well, I assume that you want it to be different. So here's the punchline. Who is the only construction project participant with the ability to provide the owner the information that will permit the owner to meet its commitments to the contractor? And, by now, I hope that you understand that that's the architect. And, when I give this, talk at John Marshall Law School, I say anybody that gets this wrong is coming to the bar with me to have a beer immediately, because we're talk about how they didn't, get the point of this. But this is what architects got to know. Don't review a submittal before you have a submittal schedule. Get the submittals you want, get them on time. Exercise the control over the rights that you have contractually. And if you're interested in this, and I bet a lot of you aren't, there's a ton of great contract at AIAcontractdocuments.org. I have a ton of content on my website, more than 75 very detailed videos on all kinds of topics like this. If you're interested in any of this stuff, you want to read in the articles, you can go to my website and get a whole lot more content like this, for all kinds of things: dispute resolution, contract negotiation, liens, various project participants. And so, that is where I'm going to sign off, and encourage you to contact me if you wish.